Hello and welcome to Raus IAS. This is Daily News Simplified for the day 18th October 2023. And for today's discussion, we have taken these four topics for prelims and two topics for mains. Okay. Now, the topics for today's discussion for prelims or DPP are anti-defection law, processes of inclusion in scheduled tribe list, sustainable development goal, and another is a location-based question. Right. And for the mains discussion, we have taken some important news of the day. The first is cannot legalize same sex marriage, which was a recent judgment by the Supreme Court of India. And the other issue we have taken, another article we have taken, is the issues in Wildlife Protection Amendment Act 2022. Okay, so let's begin today's session. Now, um the first question for prelims or DPP is inspired by this article, which appeared on the page number 1 of The Hindu, right? And in this article, the Supreme Court has given the Speaker of Maharashtra last chance to set timeline for anti-defection proceedings, right? The court has categorically said that it would not allow the Speaker to drag the disqualification proceedings till the next election. So it is regarding the issues in the anti-defection law. Okay. Now, based on this topic, UPSC has several many times asked questions. For example, in the year 2022, we found this question, which was regarding the anti-defection law. Okay, on the similar lines, we have framed today's practice question, which states that with reference to the anti-defection law in India, consider the following statements. Now, the statement one says, a member of a legislature cannot be disqualified if he has, sorry, a member of a legislature can be disqualified if he has voluntarily given up membership of his political party. Okay, so this is a correct statement. The second statement says, an independent legislature disqualifies if he joins any political party. Now, this is also a correct statement. The third statement says that any question regarding disqualification is to be decided by the presiding officer of the concerned house. Okay, now this is also a correct statement. Now let's see, anti-defection law was added in the Indian Constitution by the 52nd Constitutional Amendment Act. It was in the year 1895. Okay, so it was basically the member of any political party does not violate the mandate of that any given party. Okay, now under this law, any legislature is seen to be defected, or the legislature or the member of that political party is disqualified under some grounds. The first ground is if he voluntarily gives up the membership of his party. Okay. Other ground is if that member disobeys the directives of the party leadership That is, either if that member gives the vote on contrary to the directions of the party, or if he abstains from voting. Okay. So in both these conditions, the legislature is seen to be disqualified. Okay. Now, other grounds for disqualification provided under the anti-defection law is if an independent member can be disqualified if he joins any political party. The other ground is that any nominated member can be disqualified if he joins any political party after the passage of 6 months. Okay, from the date on which he takes the seat in his house, right? So these are the grounds for disqualification under the anti-defection law. Now, any question regarding disqualification is to be decided by the presiding officer of that house, and this decision by the presiding officer is subject to judicial review. Okay, so these are the important facts which you might need to know in this question. Now, the second question for the day is regarding this news article which appeared on the page number 4 of The Hindu. Now, this news article says that SC status for Metis is examined and rejected in 1982 and 2001. Government records show. So this news article is regarding the long pending demand of the Metis community in Manipur, which is a majority community in Manipur, regarding the scheduled tribe status. Okay, and so in this article we will see the question which we have framed is that what is the process of inclusion of any community or any group as scheduled caste or under scheduled tribe list. Okay, so we will see a question regarding this procedure. Now, based on the similar lines regarding certain constitutional provisions, we found a question in 2016 which was regarding the provisions of 5th schedule and 6th schedule. Okay. So let's discuss today's question, which says that with reference to the process of inclusion in the scheduled tribe list, consider the following statements. Statement 1 says, a state government can recommend changes to the list of scheduled tribes based on its discretion. Now, this is the correct statement. The second statement says, the proposal is forwarded by the state government to the Union Ministry of Social Justice and Empowerment. But this is an incorrect statement, as a proposal in this regard is not being forwarded to this ministry but to the Ministry of Tribal Affairs. We will see this. And the third statement says that the inclusion in the scheduled tribe list becomes effective only after the president gives assent to the bill. This is absolutely correct statement. Okay. Now let's see what is the process of inclusion of any community or any group in the scheduled caste or scheduled tribe list. Now, firstly, what happens is that any state government can recommend special communities or group either for their inclusion in any list in scheduled caste or scheduled tribe list or for their exclusion from that list. Okay. For this, it is the discretion of state government based on some criteria, be it social economic backwardness or certain other criteria. Okay. Or for the conservation or certain other criteria. And in that purpose, the state government submits a proposal to the Union Ministry of Tribal Affairs. Okay. And then what happens is that this Union Ministry of Tribal Affairs examines the proposal and then it forwards the proposal to the Registrar General of India. Okay. Now, once the Registrar General of India gives the approval, then the proposal is submitted to National Commission for Scheduled Caste or to the National Commission for Scheduled Tribes for further consideration, respectively. And then what happens is that after the union government gives approval, after the approval by the respective National Commission of Scheduled Caste and Scheduled Tribes, the proposal is further returned to the union government. And then what happens is that union government floats a bill in this regard, and this bill has to be passed by both Lok Sabha and Rajya Sabha. And after Lok Sabha and Rajya Sabha passes the bill, this is given to the president for his assent. Okay. And only after the assent by the president, any community can be included either in scheduled caste list or as scheduled tribe list. Okay. So under the Article 341, the president has the power to declare any community as scheduled caste. Okay. And under the Article 342 of Indian Constitution, the president has power to notify any community as scheduled tribe. Okay. So these are important facts which you might to know about, which you need to know about this question. And if we talk about the answer to this question, that how many above statements is or are correct, so the correct answer is only 2. Now let's move on to our next question. And this question is based on this particular article which appeared on the page number 10 of the Hindu. The article is regarding the progress of sustainable development goals. Okay. Now, as you all know that UN has, there are 17 sustainable development goals that have been recognized by United Nations. Okay. And the time period for fulfillment of these goals were 2015 to 2030. Okay. And now we are in the year 2023. 50% of this timeline has passed. Okay. And now even after half of this period is passed, the world could only achieve 15% of these 169 targets, right? So this article is about various implementation issues and other issues regarding the funding issue in developing nations. Okay. So this basically about the abysmal or the poor performance in moving towards the sustainable development goal targets, right? Now, based on this topic, we have framed a question. And in the year 2016 also, UPSC had asked a question regarding the sustainable development goals. Okay. Now, let's solve the question for today, which says that consider the following statements regarding sustainable development goals. The first statement is the Rio Earth Summit of the year 1992 led to the adoption of Agenda 21. Now, this is a correct statement. In the year 1992, in the Rio Earth Summit, which happened in Brazil, more than 178 countries adopted Agenda 21. Okay, so what was it? It was a comprehensive plan of action to build global partnership for sustainable development to improve human lives and environment, right? Now, another statement is that sustainable development goals are legally binding for all UN member states with mandatory compliance. Now, this is an incorrect statement. This is because sustainable development goals are not legally binding, and there is no penalty in case of non-compliance to any of its provisions. Okay, so this can be also one of the reason for poor implementation of sustainable development goals, right? Another third statement is, in India, Prime Minister's office is the coordinating agency for sustainable development goals. Now, this again makes it incorrect as it is not Prime Minister's office but Niti Aayog, right? Now, as the question asks, how many of the above statements are incorrect? So, our answer is only two, right? Now, let's move on to the final question for today, which is based on this news article, and we have taken some important location, and these locations are in news regarding the present conflict between Israel and Hamas. Okay. Now, as we know that regarding some important locations in news, UPSC has previously asked questions. As in the year 2016, we found this question on Golan Heights, right? Similarly, regarding some locations, UPSC can again, we can expect these questions, right? Uh, Now let's solve this practice question, which is regarding Raha border. Now the question states that the area known as Raha border sometimes appear in news. With reference to it, consider the following statements. Okay. The first statement is Raha border is the only route for aid to enter Gaza Strip. Now this is a correct statement. We will see its location shortly. The second statement is it is outside the Israel territory. Yeah, this is also a correct statement. The third statement says this is controlled by Hamas group, and this is an incorrect statement as Rafah border is controlled by the government of Egypt. Okay. Now let's see the location. Now let's see the location of Rafah border. Okay, this is the map of Israel, and this is Gaza Strip. To the south of the Gaza Strip, you can see Rafah crossing, and this is the crossing between Gaza Strip and Egypt. Okay, and this is the only sole route for the aid to enter, for the aid from Egypt to enter Gaza border. Okay, and if you can see this map, this is the only exit that does not lead to the Israeli territory. Okay, and this Raha crossing, or this location and this crossing is being controlled by Egypt. Okay, so if we talk about answer to this question, then how many above statements are correct? Only two statements are correct, right? Now we have seen the questions for prelims for today, and let's move on to the mains discussion for the day. Now, regarding the mains discussion, we have taken the most important news for today, which appeared in The Hindu and in Indian Express at multiple locations, multiple pages. And this is one of the important rulings, or one of the important judgments by the Supreme Court. Okay, so yesterday Supreme Court has given a judgment on same-sex marriages, okay, or heterosexual couples, and Supreme Court said that Supreme Court cannot legalize same-sex marriage, okay, and Supreme Court has underlined this issue to the legislature by saying that legalizing same-sex marriage is what Supreme Court can't do at this moment, and the legislature should make rules for it, right? And now this topic of legalizing same-sex marriage is important for our GS paper 2 under the syllabus head Indian Constitution, its historical underpinnings, the evolution of the Constitution, features, amendments, significant provisions, and basic structure. Okay. And this is also important for our GS paper 2 social justice under the vulnerable sections. As we know that LGBTQ community or transgenders are vulnerable sections. Okay. Now, based on this broad themes, we have seen many questions. Like in the year 2019, we saw this question in prelims, and in the year 2017, we found the mains question which said that examine the scope of fundamental rights in the light of latest judgment of the Supreme Court on right to privacy. Now, based on the similar line, one can expect a question that examine the scope of fundamental rights for transgenders or LGBTQ community, right? Or the evolution of their rights. In the similar lines, we can expect this question. Okay. Now, let's proceed further. The judgment which Supreme Court gave yesterday basically deals with four key issues. And what are these four key issues? The first issue is that it deals with four questions. The first question is whether there is a fundamental right to marriage in India. Okay. The other issue Supreme Court dealt was whether the words in the Special Marriage Act of 1954 could be given any gender neutral meaning, right? We will discuss Special Marriage Act. The third question was whether it was regarding the queer couple's right to adopt child. Okay. And the fourth question was whether a civil union can be realized under an Indian law. Okay. Now, based on these questions, we will discuss these questions and related judgment of Supreme Court. But prior to it, let us understand what are the evolution of rights for homosexuals in India. Okay. Now, for it, there are some important judgments which you should know. The first such judgment was in the year 2014 and in the landmark case of National Legal Services Authority versus Union of India, or the NALSA case. Okay. So this is a landmark case, as under this case, transgender were recognized as the third gender. Apart from male and female, transgender were recognized as a third gender, and which paved away the path to give them legal rights, to give them further more rights in future. Okay. So this was an important judgment which you should know, NALSA judgment, by recognizing transgender as third gender. Okay. Now, in the year 2017, there was another landmark judgment which was Justice K.S. Puttaswamy versus Union of India. So this is a landmark case in which Supreme Court recognized that right to privacy is a fundamental right. Okay. And this recognition of privacy as a fundamental right under Article 21 paved the way for greater recognition and protection of LGBTQ rights, among others, and their right to privacy and personal autonomy. Why so? Because sexual orientation, as per this judgment, sexual orientation is also a private. Sexual orientation is private, and it is a part of life to dignity under Article 21, right? So this is also an important judgment which you should know. Further going down, in the year 2018, an important case was Navtesh Singh Johar versus Union of India case. Okay. Now, what did this case do was it repealed Section 377. Now, what was Section 377? It was British colonial era act which criminalized homosexuality. Okay. And by this judgment, this Section 377 was repealed, or homosexuality was decriminalized. Okay. And what happened? And further in the further down in the evolution, last year in the year 2022, Supreme Court recognized atypical family units, the existence of atypical family units. Supreme Court recognized that the structure of family is changing, and it recognized atypical family units. These are the family units which can consist of single parents, which can consist of transgenders, which can consist of same gender couples. Okay. And what Supreme Court said was that all types of atypical family units are entitled to legal recognition under various social welfare legislation like a typical heterosexual family units. This means that atypical family units are also obligated, that the state is obligated to give them equal rights, equal social welfare rights as compared to a heterosexual family units. Okay. So in this evolution, we saw that we saw the process of evolution in for the transgender community or LGBTQ community, and we saw that earlier their fight was regarding the right to recognition, and now their fight is for the rights of greater order, and presently it is regarding the right to marriage. Okay, now since we saw the evolution of rights to LGBTQ community, now let us now, when we discuss these questions, let us see what are these key issues and what were the judgments of Supreme Court regarding these key issues. Okay, now first question, whether right to marry is a fundamental right in India. Okay, now under this there was a petition from LGBTQ community that the Supreme Court must address the denial of right to marriage to the LGBTQ community. Okay, now the reasoning behind this was that if the right to marriage is recognized as a fundamental right in India, then this would cast an obligation to the state to protect the right. This means that if right to marriage is a fundamental right in India, and if this right is not given to the LGBTQ community under Article 226 or under Article 32, under Article 226 or under Article 32, they can file writ petition in High Court and Supreme Court respectively for enforcement of their right. Okay, only if right to marriage was a fundamental right. Okay, and this was what petitioners were demanding, to recognize right to marriage as a fundamental right. But now let's see what the latest judgment of yesterday, what the Supreme Court said. So in the majority verdict, Supreme Court said that right to marriage in India presently is not a fundamental right, and it is a statutory right. Okay, so this was a major defeat to what petitioners were expecting. And but further, after saying that right to marriage is not a fundamental right in India, Supreme Court also said that right to enter into any union, or which it said as right to relationship, is unrelated to sexual orientation, and this is a feature of fundamental right in Article 19 and Article 21. So in layman terms, this means that though Supreme Court did not recognize right to marriage as a fundamental right, but this does not mean that homosexual couples cannot live together, as government has already acknowledged that homosexual couples have the right to cohabit, they have the right to choose one's partner, they can live together, they can choose their own partner, and they have right to one's sexual orientation, and these are a fundamental rights given to them under Article 21. But as of now, right to marriage is not a fundamental right. Okay, so this was a basic development in this case which happened. And further moving towards the second question, that was regarding the interpretation of Special Marriage Act of 1954. Okay, now the petitioner said that the petitioners wanted to recognize same-sex marriage by allowing a gender-neutral interpretation of Special Marriage Act. Okay, before this, let's understand what is a marriage. Okay, so marriage is a social institution. Okay, and marriage is a social institution which is given sanctity, and this is given sanctity either by religion, say there are personal laws for it, or either marriage as an institution is given sanctity by state. Okay, now for example, there are example of personal laws like Hindu Marriage Act of the year 1954, like Muslim Marriage Act, Christian Marriage Act, and these are the personal laws by which marriage as an institution is given sanctity. Okay, and there is other law which is Special Marriage Act of the year 1954, and under this act the sanctity to this marriage for whom? For interfaith couples, or intercaste couples is given by the state, right, under this act. Now, so this is Special Marriage Act. Now what did this petitioner demanded? They wanted recognition of marriage. Now you might think that if LGBTQ community has the right to cohabit or live together, they have right to choose one's partner, then why are they even wanting this right to marry? Okay, like what is the significant change which will happen after they get this right to marriage? Okay, now this is that this recognition of their marriage also confers, or we can say that recognition of marriage also confers some associated benefits with it. right? Now, what are these associated benefits? Like, if we talk about LGBTQ community, if if their marriage is recognized, the couple can open a joint bank account. They can claim insurance benefits. Okay, they have right of succession. For example, if one of the spouse dies, the other can inherit his property. Okay, there are benefits regarding adoption. So we can say there are various benefits, say regarding insurance benefits, regarding they can open bank accounts, and this joint bank accounts, which may seem insignificant to any heterogeneous person, but for LGBTQ community, this may be also a privilege. Okay, and the right of succession. Okay, inheritance. So this is why, because marriage as an institution, the recognition of marriage gives some civil rights to this community. So this is the demand why they wanted a legal sanctity, okay, to marriage. This is but now we see what Supreme Court said. Supreme Court clearly pointed out that the Special Marriage Act by the Parliament only mentions heterosexual couples. That is, it gives sanctity to the marriage between heterosexual couples. But this Special Marriage Act does not say anything about homosexual couples, right? So Supreme Court said that it is the prerogative of the legislative. Okay. So by so interpretation of Special Marriage Act is the prerogative of the legislative, and at this point of time Supreme Court doesn't want to do this, and Supreme Court clearly says that if this is in the domain of legislature, right? And presently, so this gender neutral interpretation of Special Marriage Act, where the term marriage between a male and female was to be replaced by marriage between two spouses. Now presently this could not be done, as this as altering or interpretation of this act is with the legislature, right? Now another issue is regarding the queer couple's right to adopt a child. Okay, now presently the petitions by the LGBTQ community was that the guidelines of Central Adoption Resource Authority CARA is discriminatory against queer couples who cannot legally marry. Now, what is CARA? CARA is a statutory body which is under the Ministry of Ministry of Women and Child Development, and this is a statutory body which was formed under the Juvenile Justice Act of 2015. Okay. Now, now under this, what happens is that CARA has given the right to adopt a child to a single male. Say, a single male can adopt a child, okay, or a single female can adopt a child. And CARA has also given this right to adopt a child to a LGBTQ or a trans or a LGBTQ, we can say. So LGBTQ community can also adopt child, okay. And now these are individual or single male, female or transgender. But if we talk about the guidelines regarding the couple adoption, so in case of a heterosexual couple, that is association between a man and women, they have a right to adopt a child, but only after 2 years of their marriage. Okay, after 2 years of their marriage. But the trans community says that they are being discriminated because a trans couple or a homosexual couple, since the marriage of this since the marriage of this homosexual couple is not legally sanctioned, right? Is not sanctioned. So that's why is not recognized. That's why this trans couple cannot legally marry. Okay, and that's why any homosexual couple cannot adopt a child, right? So they feel that this is discriminatory against these transgender couples, right? Now in this regard, what the Supreme Court said was, Supreme Court said that this change in this guidelines by CARA, this cannot be achieved by judiciary, and rather this remedy is to be provided by legislature. Again the same thing, that judiciary cannot intervene in this issue since it is in the domain of legislature, right? And now let's move on to the third question, to the last or the fourth question, fourth issue, which was regarding civil unions for queer couples. Okay. Now, what is a civil union? Civil union is a some kind of legal recognition to same-sex marriage. Okay. No, same-sex couples. This is not marriage. Uh, Civil union is not marriage, but it is some kind of legal recognition to same-sex couples. Then USA has given a recognition to same-sex marriage, but earlier it followed the route of civil union, and this is some kind of legal recognition. Now, what was the petition? So there was a petition. So there was a question regarding that. Can civil union, as for some time, it could give some legal recognition to transgenders, and can it be given to the queer couples? But the transgenders or the LGBTQ community was of the opinion that this would send a message that the homosexual relationships are inferior to the heterosexual couples, because civil unions are not an equal alternative to marriage, right? So they thought that this would mean that homosexual relationships, since they are getting recognition under civil unions but not under marriage, they are somewhat inferior to the heterosexual marriage, right? And this is what they didn't want. But still, the Supreme Court has said again that the court or Supreme Court cannot prescribe a choice of civil unions to queer people. And this again is what a legislature can do, right? Now, we've seen the development with Supreme Court. We've seen the judgment of Supreme Court and the development regarding it. Now, let's also see what are some positives regarding the judgments of yesterday, right? The Supreme Court has given some certain directions to the state government and to the union government. And what are these directions? The first direction is regarding the non-discrimination of LGBTQ community in terms of access to goods and services. That is, there shouldn't be any discrimination to this community in their access to goods and services. And this is the directive given by Supreme Court to the central government and state government. Another directive given is to increase the public awareness about the rights of the LGBTQ community, and to increase the awareness of the people, and to uh, to establish this notion that this LGBTQ is they are like they are fully functional humans, and this is not a certain kind of mental illness or disease as is a common perception. Okay, this is not what I am saying. This is quoted by Supreme Court, right? And now the other directive is to establish a helpline for queer community. Now this helpline is to be established such that this queer community, if it is in any kind of distress, if it is be if the community, if any member of the community is being harassed, or any kind of violence is being inflicted upon him, then there should be a helpline so that that person can connect. And then one of the important thing which Supreme Court directed was for the establishment of safe houses or the establishment of Garima Grahas. Garima Grahas should be created in every district of India to offer protection or shelter to the queer couples, right? Also, Supreme Court has said that the forced operations of intersex children should cease to exist at immediately. That is, sometimes there are certain forced operations of these intersex children to change their gender. Okay, but these children may not, they may be below a certain age and they may not be able to give consent to this operation. So the Supreme Court has said that such kind of operation without the consent of these children should not be done. Okay, should be immediately seized or stopped. Now another important thing is that the Solicitor General of India said that the central government is thinking for the formation of committee to decide the rights and entitlements of person in the queer unions. That is, there is a certain that a committee is to be established which will see regarding the rights of transgender community as a family in ration cards, allowing the queer couples to nominate for joint bank account, allowing them the right from pension, gratuity, or other certain social benefits, right? So for it, a committee is to be established by the central government. Now, after it, Supreme Court has also given some directive to the police. These directives are regarding, the first directive is regarding no harassment of the queer couples by the police. And this may be like police may sometime may like to not summon them in police stations or to visit their residences solely to inquire about their gender identity, right? So this is to prevent any kind of harassment or to the trans community. Okay. The other directive given to the police is the freedom of choice. That is, the queer individual should not be forced to return to their families if they wish not to return, right? And there is also a directive regarding their protection of freedom and to protect them against violence, right? That is, when a queer individual files a complaint against family, inhibiting their freedom, or the family is inflicting any kind of violence against them, then the police should verify the genuineness of the complaint and should provide appropriate protection to this community, right? So in conclusion, we can say that the government should work on implementing these directives, and also with it, India needs a separate anti-discrimination law which prohibits discrimination based on sexual orientation. Presently, we have various anti-discrimination mechanisms, but these are not consolidated enough. So India needs a separate anti-discrimination law for LGBTQ community in order to prevent them from discrimination based on sexual orientation, right? Now, let's move on to our final topic for today's discussion, which is regarding this article which appeared on the page number 9 of The Hindu. Now, this article says that when tigers and jackals get the same protection. So, this is regarding some issues in the Wildlife Protection Act amendment which happened in the year 2022, right? So, this article is important for our GS paper 3 Environment and Biodiversity under the syllabus head Conservation, Environmental Pollution and Degradation, Environmental Impact Assessment, basically under the conservation provision, right? Now, based on this theme, we found a question in the year 2022 in prelims, which was regarding a Schedule 6, which was regarding Schedule 6 in Wildlife Protection Act 1972, right? Now we see, let's discuss what is the context of this article. Okay, the context of this article is that many ecologists in India are concerned regarding the inordinate addition of a number of species in the new schedules of Wildlife Protection Act Amendment Act 2022 without any objective process or criteria. Now, what does this mean is that, first of all, India had a Wildlife Protection Act 1972. Okay, so this was an act which provided legal framework for the protection of various species of wild animals and plants in India for the management of their habitats, for the regulation and control of trade of wild animals, plants and products made from them. Okay, so this was a legislation of India, right? And in this act, in this legislation, there were certain schedules. And if you remember, there were 6 schedules in this constitution, right? Which provided, which classified different level of protection to these plants or to these flora and fauna, right? Now, what happened is that in the year 2022, there was an amendment in the Wildlife Protection Act, right? And in this amendment, there were certain clauses for which the ecologists are concerned regarding it. One such issue is the addition of inordinate or a lack of objective criteria in addition of certain species in certain list, right? Now we will discuss this, like for example, in Schedule 1 of Wildlife Protection Act, which offers highest protection, and it consists about 600 species of vertebrates and invertebrates. Also in Schedule 2, it consists about 2000 species. So without any objective classification, there has been huge addition of species in this act. So overall, we will see what are the challenges in this amendment or what are the concerns regarding this amendment. But first, let us see that what are the positives. Let's see what are the positive key features of the Wildlife Amendment Act of 1900 of Wildlife Amendment Act 2022. Let's see this. Now, the first positive key feature is the holistic approach by which the new legislation is moving forward. Now, in the Wildlife Protection Act 1972, there was a provision for protection of wild animals, birds, and plants, right? But now, in this new amendment, this has been replaced with conservation, protection, and management of wildlife. That is, the domain has been increased to conservation of wildlife in their habitats, further further the protection of their ecosystem, right? So the approach, the ambit of this has been widened, and this focuses towards a more holistic approach in conservation of the wildlife species. It has moved from just protection to conservation, protection, and management of wildlife, right? So this provides a more holistic approach of conservation, right? The other positive key feature is invasive in addition of invasive alien species provision regarding it. Now earlier in the Wildlife Protection Act 1972, there was not any provision regarding the alien species, right, which are harmful to any native environment, right? Now what happens now under this act, the central government under this act, under the new amendments, it empowers the central government to regulate or prohibit import, trade, possession, or proliferation of invasive alien species, right? And in this regard, the central government may authorize any officer to seize and dispose invasive species, right? So this was an important provision regarding the inclusion of invasive wildlife species in the new amended act. The other provision is addition of new schedule. This is an important provision. It is addition of new schedule for specimen listed under the CITES framework. Now CITES is an international framework. CITES is an international framework regarding the regulation of international trade of flora and fauna, right? Now the certain species which were added in CITES, they were not added. Certain species which were present in CITES, in the appendix of CITES, they were somehow not added in the earlier Wildlife Protection Act by now, but now in the Amendment Act, there is an addition of a new schedule for the specimen which are listed under the CITES list. So we can see that this is the old, on the left hand side, these are the earlier schedules of Wildlife Protection Act 1972, which consisted of 6 schedules. Now the number of scheduled in the amendment acts have been reduced, and the new amendment act has 4 schedules. In this, schedule 4th mentions the specimens listed in the appendix under CITES, right? So this is for the better regulation of trade of flora and fauna and better conservation of these endangered species. Okay, and other issue is regarding the management authority. Okay, now for it, a management authority will be appointed by the central government for issuance of permits and certificates for trade in scheduled specimens in accordance with CITES. Now until now, what happens that the CITES provisions, the provisions of CITES were enforced through Customs Act, right? And not through, and there was not a dedicated Wildlife Protection Act for it. But now there is a dedicated environmental legislation or a forest legislation for it, which can give it better enforcement power, right? The other positive aspect is decentralized management. Now what happens that for sanctuaries, which fall under special areas, say some tribal areas or other special areas, their management plan must have to be prepared after due consultation with the concerned Gram Sabha, right? So this is certain kind of decentralization of power in which the Gram Sabhas are taken into account, right? And the other major provision is declaring conservation reserve by the center. Now earlier what happened is that areas adjacent to national parks and sanctuaries could be declared as conservation reserve by the state government only. But now after the new amendment, this conservation power after the amendment, any center and state government both can declare these areas as conservation reserve, right? Also, there is a provision regarding the surrender of captive animals. Okay, now under this provision, what happens is that any person who is having a certificate of ownership, that person can voluntarily surrender any captive animal or animal product to the chief wildlife warden, right? So it is regarding the surrender of captive animals to the chief wildlife warden. Okay, so these are some important positive features or positive aspect of the new Wildlife Amendment Act. Now, despite these features, there are certain challenges regarding this act and which are a matter of concerns with the ecologist. Now let's discuss these issues. The first issue is reduction of schedules. As we earlier saw that in the Wildlife Protection Act 1972, there were 6 schedules, and under the Amendment Act, there are only 4 schedules, right? But what happens is that after the schedules were reduced, there was this led to a huge number of species falling to the same list, right? That is, the management of species under this schedule were not did not hold any objective criteria. For example, as the title of today's discussion was, that jackal and tigers will fall under the same schedule. This means that now, as tiger, you know that tiger is a schedule 1. Tiger was mentioned earlier under schedule 1, right? But now under the new classifications, jackals, which are relatively more common, the numbers are more compared to jackal, they are also mentioned in schedule 1, right? And the schedule 1 also consists great Indian bustard. In the same hand, it also consists of common barn owls. Schedule 1 also consists of king cobra, and it also consists of rat snakes. That is, there is no objective criteria how these animals are clubbed together in schedule 1, right? And what is the major issue which arises out of this is regarding the distribution of resources, regarding the prioritization or distribution of regard or the distribution of regard sorry regarding the prioritization or distribution of resources in order to prioritize any species over other. So these are the challenges, okay? The challenges of using resources and prioritization of species, as various species have been clubbed together. Another issue, the related issue, is unscientific classification. For example, spotted deer or cheetal has been classified in schedule 1, which gives the most protection status, right? But this cheetal is common throughout India. And if we talk about Andaman and Nicobar, this cheetal is an invasive species, right? But as cheetal has been included in schedule 1, then the killing or hunting of cheetal will not be allowed. So how can an authority in Andaman and Nicobar can kill cheetal, right? So this is an unscientific classification, as any such species cannot be legally killed or removed because of now new amendment in the Wildlife Protection Act, right? Another major challenge is regarding the dilution of federal framework. Okay. Now earlier, under the Wildlife Protection Act 1972, the state boards of wildlife were created, which was chaired by the chief minister, right? But now after this new amendment, these boards have been defunct and their power has been transferred to a standing committee which is headed by a union forest minister. So somehow this upsets the state governments, right? As this is seen as a dilution of federal framework by the central government, right? Now another concern is regarding using animals for religious purposes. Now under a section 43 of this act, that is under a particular section of this act, elephants, which are schedule 1 animal, they are permitted to be used for religious or any other purpose. Now there is a concern that as these animals can, as elephants can also be used for any other purpose. So this addition of this clause for any other purpose is a matter of concern. Why? Because this can leave the door open for commercial trade of elephants, right? As the clause of using them for any other purpose can make it easier for the animals to be transported across country, right? So this defeats the purpose why elephant was first included in the schedule 1 of Wildlife Protection Act, right? Also, there is an issue of lack of ownership. As we earlier saw that the people who had the certificates regarding the ownership of elephants or particular species, they could surrender those species to the chief wildlife warden, right? But as for an example, there are many people who have animals in captivity, but they don't have any certificates regarding them. So such people cannot surrender these animals, right? So this is a major loophole in this act. And further, finally, we can say that inclusion of many animals in Schedule 1 without any objective criteria may hamper research, as listing so many species in Schedule 1 will impact research in getting permits for research in this species would become tedious or time consuming. Okay, so this was all regarding the concern why ecologists are concerned regarding the new amendments in the Wildlife Protection Act. So that's all for today. So I'll be ending the discussion soon. So thank you everyone for